Hello and a very warm welcome to latest case analysis series by LawSikho. For today's discussion, we have taken up a Supreme Court decision which is dated 6th of November 2020. The name of the case is Indian Olympic Association versus Kerala Olympic Association and others. It is a single bench decision of the Honorable Supreme Court, and the bench consisted of Honorable Justice V. Subramanian. Now let's proceed and understand the issue of law. So the court was to decide whether lack of jurisdiction can be a ground for seeking transfer of a matter from one high court to the another. Now let's proceed and understand the brief facts of the matter. And also, I'm sure as we proceed further with the case analysis, we'll be in a position to understand the nuances of the issue of law involved and the answer which the court provided to such a question. So, the petitioner in this particular matter is the Indian Olympic Association, while the respondent number one is the Kerala Olympic Association, which is affiliated to the petitioner. In the year 2019, elections to office bearers of respondent number one they were held, and these elections they were conducted under the supervision of Kerala High Court in view of writ petitions which were filed therein, that is before the Kerala High Court. Now, respondent number six filed a complaint, and the Ethics Committee Commission of the petitioner, which is the Indian Olympic Association. So, the Ethics Committee of Commission of the Indian Olympic Association, it took cognizance of the contents of such a complaint, and this was also governing the 2019 elections. And in pursuant to such a complaint, the Ethics Commission it issued a notice to respondent number one proposing to conduct an inquiry into the elections of 2019. Now, a writ petition was filed in Kerala High Court by respondent number one, and respondent number one in this writ petition challenged the proceedings which were initiated by the Ethics Commission. Now, why was these proceedings initiated and why were these challenged? We'll understand this provision later on in the case analysis. So now, when this writ petition it was preferred before the Kerala High Court, so the petitioner, which is the Indian Olympic Association, it sought transfer of the proceedings from the High Court of Kerala to the High Court of Delhi before the Supreme Court, and hence we're dealing with this particular matter. So let's first understand the cases or the arguments which were advanced by the counsel of both the petitioner and the respondent. So let's first take up the case of the petitioner. So, the Indian Olympic Association it contended that as per its bylaws, which were also binding respondent number one or which were binding upon respondent number one, so as per such bylaws, any proceeding against it, that is against Indian Olympic Association, so any proceeding which could have been or which can be or which is instituted against the Indian Olympic Association, it could be filed only in a court within the jurisdiction of Delhi High Court and not in any other court, and hence this transfer petition was sought. Now let's briefly have a look at the relevant clauses of this bylaw, the bylaws. So clause 22.6 it provides that all matters in relation to breach of ethics shall be referred to the Ethics Commission of the Indian Olympic Association as per the regulations of the Ethics Commission. And another clause provides that the association may sue or be sued in the name of the Secretary General Indian Olympic Association. A lawsuit can only be filed at New Delhi, the headquarters of Indian Olympic Association. Another clause, which is 28.8, was the affiliated state Olympic Association, like the Kerala Olympic Association, will abide by the constitution of the Indian Olympic Association. So, essentially, by virtue of these clauses, it was contended that any matter which was before the Ethics Commission, so it had to be dealt with by the Ethics Commission if it involved any ethical conduct, breach of any ethical conduct. So that has to be dealt with by the Ethics Commission. And if any person wants to sue the Indian Olympic Association, then such a suit has to be instituted at New Delhi, which is the headquarter of the Indian Olympic Association. And all the state Olympic associations which are affiliated to the Indian Olympic Association, they are to abide by the constitution of the Indian Olympic Association, essentially submitting that they are to abide by this These clauses, which reflects on the fact that a lawsuit has to be instituted in New Delhi alone. Secondly, it was contended by citing the case law of RV Industries and others versus Ratan Lal Sharma that the Supreme Court had held that if a particular suit is instituted deliberately in a wrong court, so such an institution of a suit in a wrong court, it cannot be a bar or it cannot be it cannot have any bearing on the question of transfer. So if a transfer is sought from one court to another, then the fact that the suit was instituted deliberately in a wrong court, this cannot have any bearing on such a question of transfer. This was contended by the counsel for the petitioner, citing this case law of the Supreme Court. Thirdly, it was contended and further precedents for this were also cited, and it was contended that the Supreme Court directed the Indian Olympic Association to follow particular rules requiring members to voluntarily surrender their right to seek redressal in any other court, and hence the court which is left for seeking such a redressal is the Delhi High Court or any court within the jurisdiction of the Delhi High Court. Now let's proceed with the case of the respondent number one. So it was contended that the validity of the election of office bearers to respondent number one, which were held under the supervision of the Kerala High Court, they could not have been taken away by the Ethics Commission because the authority exercising jurisdiction over such election was the Kerala High Court. Now, having understood the cases of both these parties, let's proceed with the reasoning and decision of the court. So, the court stated that the contentions of the Indian Olympic Association that Kerala High Court was devoid of any jurisdiction, it was flawed because it was flawed. However, the Supreme Court refrained itself from deciding the issue of jurisdiction since the matter before it was only governing transfer, which sought the transfer of the matter from Kerala High Court to the High Court of Delhi, and hence it did not feel it mandatory or did not feel it fit or valid to issue any remarks on the issue of jurisdiction. However, the court noted that the Kerala High Court was devoid of jurisdiction. This contention of the Indian Olympic Association, it was flawed. Secondly, the court, with respect to the issue of law, this finding was given that if a court has no jurisdiction to try a list or a litigation or an instituted suit, it is good for the party raising issue of jurisdiction to seek either the dismissal or return of the proceedings rather than seeking a transfer. So the court essentially stated that if the court which has no jurisdiction to try a particular matter, then here in this particular case, the party which is opposing such an institution of a suit in such a court which does not have the jurisdiction to do so, so the right course of action for such a party would be to seek dismissal or return of the proceedings and not the transfer of it. And extending this particular reasoning, the court stated that it failed to understand why the Indian Olympic Association was so anxious to make irregular proceeding, which was filed or instituted by respondent number one, regular for such transfer. So essentially, the court, with respect to the factual aspect of this case, stated that since the suit which was instituted by the writ petition which was filed by respondent number one, so that proceeding it was irregular in terms of the fact that such a proceeding could not have been instituted in the Kerala High Court, which was the contention of the Indian Olympic Association. So, why was the Indian Olympic Association so anxious to make an irregular proceeding, which was termed as irregular according to itself, a regular proceeding by seeking a transfer of it to Delhi High Court? So, had the transfer been allowed, the matter would have been proceeded further with by the Delhi High Court. So then an irregular proceeding would have turned into a regular proceeding. So the court failed to understand as to why the Indian Olympic Association was so keen or anxious on making an irregular proceeding a regular one. Now, fourthly, the court stated that the decision in the case of RV Industries, it provides no answer to this contention as the Supreme Court did not say in that case that invalid proceedings may be validated at the instance of the opposite party by transferring the same to a court having jurisdiction. The court further noted that the registration of respondent number 1 was under a different statute which was governed by a particular state and not the statute under which the Indian Olympic Association was registered, and this fact it was not disputed by either of the party. Now the case which was pending in Kerala, it related to election of office bearers to respondent number 1 and not to election of office bearers of the Indian Olympic Association, and hence the respondent can contend, or it was right on part of the respondent number 1 to contend, that any interference by the Indian Olympic Association with internal affairs of respondent number 1 is amenable to the jurisdiction of the Kerala High Court. Therefore, in light of these therefore, in light of these observations, the court finally held that the transfer petition was dismissed. It was dismissed, and the court, however, gave liberty to the Indian Olympic Association to raise an issue of jurisdiction before the Kerala High Court itself and get any finding with respect to the same by the court, which is appropriate in this particular matter, and the appropriate court would be the Kerala High Court. Now, if we go back to the issue of law, the answer to our issue of law is given in negative, which is whether a lack of jurisdiction can be a ground for seeking transfer of a matter from one high court to another. So the court stated that no, such a ground cannot be a valid ground for seeking a transfer of a matter from one high court to another. It can at best be challenged to get the dismissal of the particular proceeding involved. At the end of this note, you may find a list of abbreviations which we have used in the note. You may refer to them, and thank you for being with us.